Greetings and a warm welcome to all the dignitaries present here. I'm Rimpa from Clarinet, serving as the allocated session assistant to ensure a seamless experience. Clarinet proudly stands as India's most relied upon digital platform, offering a multitude of enriching services exclusively for the doctors. It is with great pride that Clarinet serves as a data partner for this event, and the focus of today's session is medical legal session. Now, I would like to invite Dr. AL Meenakshi Sundaram, sir, a distinguished anesthesiologist and academic leader. Sir has served as Dean and DME at several government medical colleges, including Theni and Stanley Medical College, Chennai. He is a former National Vice President of the Indian Society of Anesthesiologists and has key positions in including Governing Council member, President and State Secretary of the ICSA TamilNadu State Branch. Now, without further any delay, over to you, sir. Thank you.
Thank you, Clarinet, for the introductory remarks. Now I welcome all of you to 46th webinar of Puthukkottai Bhudhan Second edition. And the 45th edition of Puthukkottai Bhudhan was conducted last week. The theme was transesophageal echocardiography. And 973 delegates participated live. The faculty were PG Dr. Prashant from Chitra Tirunal Institute, Trivandrum, and Mamata Munaf, Assistant Professor from Chitra Tirunal, Trivandrum, and Dr. Rohini Mayur Balaji from Apollo Hospitals, Trichy, which was moderated by Dr. Saravana Babu, AIMS, Madurai. Now, in this webinar, as I used to say, usually this Pan-India webinar comes. Now, today it is going to be a Pan-India webinar because two lady faculty are from Maharashtra and another faculty is from Tamil Nadu and the moderator is from Karnataka. So, most of the time it will be clicking like that at 50-50, like Meenakshi 50, Sundaram 50. 50% male and 50% female. Even last time also it had happened like that. And this time also it is happening like that. It is a great coincidence. The youngest faculty today is Dr.Rutukja Mahadeo Ekatpure, and she is the postgraduate from Maharashtra, and she was handpicked by Dr. Pratipa Kane. And she has done as MBBS from Solapur, that is VM Government Medical College, and DA from Siam Hospital, Mumbai. She had experience in working as junior resident in Chian Hospital and Baramati Hospital, and she has good command in handling the critically ill cases. She is having excellent communication capabilities, and she is interested in managing high-risk cases, regional anesthesia, and pain clinic, and she is interested in ICU management also. The best part of it is she is an eligible bachelor. So that has to be mentioned here. And another point also I want to add, she is interested in football. So I don't know whom she will be treating as football. So people have to be very careful. And she will be followed by Dr. Krishnamurthy sir. Krishnamurthy sir is well known here as SNK. He is qualified in law. That is the best part of it. Sir is a MD and a DPNB graduate. So usually we used to say DPNB has more weightage because of the stricter examinership. Yeah. And he has cleared both MD and DPNB. And additionally, she is a Bachelor of General Laws and a PG Diploma in Medical Laws and Ethics and a certificate course on medical law, consumer protection legislation, and administrative law, then right to information. See, now you know why sir is here as a faculty. Puthukkottai Bhudhan will be very choosy in selecting the faculty. And sir is a retired professor from Government Theni Medical College. And sir is taking active interest in ISA activities also. So he is president of Madurai City Branch for 1 year. And he has enormous PG teaching experience and undergraduate teaching experience. The best part is he is a strict disciplinarian, and he will not crack jokes, or even he will not take anything for the sake of granted. So he is very strict in that, and he has won a Saraswati Endowment Memorial Award, and he has active participation in all CME conducted by Madurai, and he is for the chairman of Scientific Committee of Anesthesia for Extremes of Age, and he has participated as a faculty in various national and regional conferences. He is well known as a person for law. So we welcome sir for this webinar, and it will be followed by Dr. Pratipa Kane. Pratipa Kane is also a LLB. So now the delegate should know why these people are here in the medical legal session. And usually we will not encourage senior faculty for the simple reason we want to bring the younger talents. But it is painful to note the present day generation is not aware of medical legal implications. That is the reason why we have to bring the stalwarts in anesthesiology as well as law. So it is pertinent to note that Dr. S.N.Krishnamoorthy is qualified in law. Dr. Pratipa Kane is also qualified in law. She is attached to Jahangir Hospital, and Madam is a golden lady. She has won gold medal in MD anesthesiology exam, and she is a diploma examiner. She is a national board of examiner, and she has credited with the LLB with the honors. So she is also qualified in law, and she has received certificate from Oxford, United Kingdom, because whenever we receive certificate from foreign countries, then only we will respect them more. So Madam has received from UK, and she is a medical legal consultant, and she is interested in healthcare communication and NABH certification, and she has contributed so much. She is a faculty for a certificate course in anesthesia, and he is a contributor for Spark project, and she is a faculty for courses. She is taking active part in Medico Legal Society of India, which I want to mention. She is whenever the founder Rajiv Joshi, secretary, filing cases, most of the affidavits are from her only. She is taking very active part in filing legal petitions to safeguard doctors. This Medical Legal Society of India is taking care of doctors' interest as far as negligence is concerned. And Madam has a tall stature. You have to see to believe. She will be nearing 6 feet. The tall stature, but she is interested in bonsai gardening. I don't know why that paradox has happened. And she is interested in clothes and jewelry designing. She will be wearing only one jewelry. Other jewelry will be her smile, evergreen smile she is always having. And she is interested in traveling and swimming. Quite naturally, she is good in picking up the postgraduates also. So she has picked up Rutuja this time. And when these two stalwarts in law are participating in a webinar, we need another great person to moderate them. He is also qualified in law. He is none other than Dr. Shivkumar F Kumbar. He is known for his legal setup. He has done his MBBS from Gulbarga, a DA from Karnataka Institute of Medical Sciences, and LLB from Karnataka University, and also LLM from Shivamoga. So he has not stopped with law. All the three are qualified in law. He is qualified in MBA Hospital Administration, MA Journalism, and PG postgraduate in Medical Legal Systems, postgraduate in Medical Law and Ethics, and CCEPC and IAPC, Pain and Palliative Care, and certificate in Dispute Management he has won. So he is good at settling disputes, and he is a fellow in Indian Academy of Medical Specialties. So he has been a bioethics international chair in UNESCO meetings, and she is a life member in Sexual Medicine Association. So in addition to that, he is a vice president IMA Karnataka, chairman IMA Academy of Medical Specialties, president ISA state branch. So he is great in IMA as well as ISA, and he is an honorary professor in IMA, National Academy of Medical Sciences. He is an IMA headquarters member, and as today, he is a consultant anesthesiologist and a medico-legal advisor. He is settled in Dharwad. The idea of this lengthy introduction is the great people have reached their position not simply. The great amount of hard work is behind their success. And those people are finding time to cater to the youngsters regarding these medico-legal problems. And at this point of time, I want to inform that I have taken over yesterday as President-elect ISA National. And this is the first meeting I am hosting as a governing council member of ISA. The first task I have taken is these medico-legal problems only, and we are devising a medico-legal team. And I request these three people, Dr. Krishnamurthy, Dr. Pratipa Kane, and Shivkumar F Kumbar, who are anesthesiologists and also qualified in law, to take part in that. So I will be communicating to these three with 3 GC members and 3 lawyers. This is my status because this is just like 9 jewels. We have to be 9. So slowly we will elaborate on that. And now I hand over the session to Dr. Shivkumar Kumar. Sir, please take it over.
Yeah. Good evening, President Dr. Manian, Secretary Dr. Kannan, Treasurer Dr. Hema, and Academic Chairman Dr. Meenakshi Sundaram. And day for yesterday onwards, he is the President-elect of ISA National. So thank you very much for the brief introduction. And today is a very important topic. I should appreciate the Dr. Meenakshi Sundaram. So as soon as he taken a charge as the President-elect, he never stopped, okay? And very next day he started planning his academic activities. And I'm very much sure that in his period, probably all ISANs of India, to a certain extent, they suffered themselves by being good in their medicine and law. So everybody knows that not knowing, it's not an ignorance. Probably you may have to suffer either in the police station or in the whatever in the capacity, wherever you are being tried over there. So to come out this crisis, to impart the knowledge, and he has selected 3 very important and eligible, well-known academicians in medicine and law. And with this few remarks, now let's proceed with the medical legal academic talks. The first one is Dr. Rutukja, who is going to talk on informed consent. So with this, let us spend a lot of time in the introductory session. And it's a never ending, okay? It's not written in most of the books. It's only how exactly we interpret and defend in the court of law and succeed in future. So Dr. Rutukja, would you please continue with the informed consent talk?
Yeah.
Yes,
Share your
ma'am.
screen, Rutukja.
Yes, ma'am.
Just make it slideshow.
Yes.
Yes. Okay. You can continue.
So, good evening, everyone. My today's topic is informed consent. So, what is consent? In healthcare, it is a permission or an agreement given voluntarily by a competent patient for any medical procedure. Most of doctors rely on implied consent for any medical examination, investigation, and treatment. Express consent is now recommended for all interventions with risk. So there are the ethical and legal requirements for an informed consent are when consent becomes an informed consent when the doctor has given the patient all the information required for him or her to make a choice, information about the procedure like general anesthesia, spinal anesthesia or block, the benefits like the sleep, analgesia, post-op pain relief, the risk associated with the procedure like nausea, vomiting, sore throat, headache, the safe options, and answering all about their doubts, fears and consents. The 3 essentials of a legally valid consents given in Indian Contract Act are competence, means patient must be sound, must be adult, not under the influence of alcohol or drink, and mentally sound. Information, patient must have enough information to make an informed consent and help with the decision making. Freely given, consent should not be given in any hurry, time pressure, or coercion. No misrepresentation. Essential foundation of consent is the patient's autonomy, which was brought into the limelight in 1914 in this case of Shondorf versus Society of New York Hospital in 1914, which was saying every person of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commit an assault for which he is liable in damages. The ethical foundation of consent. Just a second, ma'am. Patient's autonomy is ensured by Article 21 of the Constitution of India, which was saying right to life and liberty. A competent patient has the fundamental right to determine what is to happen to his or her body. When a doctor seeks consent, he respects this right of autonomy of these patients. So, how can the patient exercise his duty, his right to autonomy if he doesn't have enough information? It is the duty of the doctor to provide the patient's information and create understanding. So, informed consent is required. What is medical paternalism? When doctor tells their patient what is to be done is called as medical paternalism. We do not discuss any risk or options. Medical paternalism is actually an antithesis of autonomy. In this case of Samaira Kohli versus Prabha Manchanda in 2008, Supreme Court of India in its judgment stated that consent for a diagnostic procedure cannot be considered as a consent for therapeutic treatment. So the consent or refusal has to be documented. Document all the comorbidities and risk explained. Documenting refusal is also as important as documenting consent. The last formality is authentication or agreement by signing of the consent form by the patient. The information related issues which makes the consent invalid, like when risk were not explained, not discussed, did not understand the risk on the consent form, when did not get time to read the form, when did not have time to think, and costs were not disclosed, and there is a non-disclosure of the infrastructure deficiencies like ICU and blood bank. There are some common reasons for holding any consent invalid, like patient is competent but form has only relative signature, patient has not signed the paper, then consent for one procedure and another one is done, like GA, consent for GA has taken and spinal is given, extending the surgery beyond the consented to the convenience of the patient, name of the anesthetist not written on the consent form, then no signature of the doctor on form, and dates of the signing of the form are incorrect. Consequences of an invalid consent in consumer court. In this case of West Bengal, the hospital held liable to pay because risks were not explained and signature and date were wrong. So they have to compensate for the 3,25,000. In this case, Pune police booked 11 doctors for the death of the heart patient and as an assault because improper consent was taken and risks were not explained. Written consent is always a statutory requirement under the following acts: MTP Act of 1994, Transplantation of Human Act 1994, and Clinical Trials ICMR. In this case of Karnataka, the transplant surgeon did not take the specific consent for pancreas transplant along with the renal transplant, so he was liable and he lost his license for practice 1 year under the IMC Act. So how to give information regarding consent, either via counseling, via leaflets, videos, websites in the regional languages we can explain. The barriers of an informed consent, main three barriers are time. When there is no time to have a prolonged patient contact, it is frequently limited in a single encounter over a short period of time in immediate preoperative period. Education, when the patient is ignorant and cannot give an informed consent. And surgeon, when surgeon asks us not to disclose any risk regarding the procedure. So the patient-centric consent is a process, not just an act of signing a form. In this process, there are 5 essentials of an informed consent in a planned procedure, not in emergency situations, are the patient must be competent, patient must have enough information and time to make an informed choice, then patient must give the opportunity to discuss his doubt, fear and concerns about the procedure. Patient must voluntarily come to an agreement about the plan, and consent or refusal has to be properly documented and authenticated. In emergency, consent is not required to save a limb or life. As Parmanand Katara said, human life is more important than legal formalities. Thank you all.
Yeah. Thank you, Dr. Rutuja, for the wonderful presentation. You have covered most of the basic things in informed consent and quoting the Samrakuli case also. And whereas there are different types of consent where exactly it's required. And what I would like to stress upon this is the consent for particular specific, it has to be procedure specific. And also, even most of the times we deal with the transfusion of the bloods, either in the ICU or intra-op, post-op. The consent for the blood transfusion should be taken separately. This is also very, very important. And few procedures where exactly you need to put a central line or ICD, a spinal anesthesia, or LP also for the therapeutic purpose or diagnostic purposes. You need to have an informed consent from the patient. The patient is less than 18 years, we need to have a consent of the guardians or legal guardians or the parents. This is very, very important. And it is not like, it is something like it's a process rather than saying that even in India, even in the MCI, there are no specific guidelines of exact thing, but you need to, I would say that probably specific and also informing the patient
Rutuja.
benefits, risks also, alternatives also. Thank you very much. And we'll go ahead with the second talk, and questions we'll take it after all the speakers finish their talk.
Rutuja, stop sharing your screen.
Yeah.
Okay, ma'am.
Rutuja.
Yes, ma'am. Yes, ma'am.
Okay. Yeah. Thanks.
Yeah. I think next Dr. Pratibha or Dr. Krishnamurthy sir. Dr. Krishnamurthy sir.
Yes, sir. Ready, sir.
Yeah. Sir,
Your
already
choice.
So shall I
Meenakshi
do?
Sundaram has
Okay. Shall
yeah.
I do documentation? Then he does the.
Yes, yes.
That will
That will
be
be
fine.
nice.
Yeah. Okay,
I
Dr.
think
Pratibha.
that will be in a better sequence.
That will be all.
So can you see my slide?
Yeah, we can. We can see.
Okay. I just put it on the slide. All right. Good evening, everybody. And Dr. Meenakshi, thank you for that wonderful introduction. And today, for all the people who are watching, I think this is one of the most important topics of our session today. And that is decoding, and I have given it the title, Decoding the Power of Documentation. And in short, what is not written is not done. And in this session, I am proposing to even touch a little on the inevitable transition from physical documentation to digital one, because it is going to come very soon. So we as doctors, we find documentation really burdensome. And usually when it's the end of a case, you really want to go, but your documentation is not complete. What usually happens is that you delegate, you ignore, or you leave them incomplete. But this attitude of neglect towards documentation is really dangerous in the present landscape of enhanced accountability and litigation. You can see that millions of cases are being registered every day, every year. And the main cause, 60 to 66% of cases are being decided against doctors for improper consent and improper documentation. And please let me tell you, even residents are not spared from this. So what the Institute of Medicine and Law, they are calling these two the giant killers of doctors in Indian courts. So how do we defend these excessive litigation? And the only way to do this is through thorough documentation. So when you think of defense, you think of documentation because it's the only evidence of our reasonable standard of care. So there are other values for documents. So you have administrative value, you need your patient's ID and everything, legal protection, of course, financial billing, claims, research and audit. So if your documentation for research and audit is not correct, you may actually land up with, retraction of your full research. Education and training, of course, and data. You need data for auditing, for policy, making policy and planning. So let's just look at the basics of documentation. It is the ethical and legal duty of the treating doctor to create this evidence of continuity of care. And this has been given in the NMC 2019. The responsibility of the content and its accuracy is entirely on the treating physician. And today, documents have a very enlarged scope. So, in fact, all patient identifying information, what we call PII, clinical photographs, videos, audio recordings, printouts from monitors, emails, text messages, even bills can be produced as evidence. Now, a good medical record needs good clinical content, and it must be scientific compilation of the patient's medical history, examination, investigations, diagnosis, treatment, and its progress. So the key documents for the anesthesiologist are the pre-anesthesia consultation record. If that document is not there, it is by itself held as negligence. A separate written informed consent for anesthesia on the agreed plan of anesthesia, risks and benefits, as she has already told, has to be recorded in the consent. Safe surgery checklist is another very vital, important document. Perioperative anesthesia record with adverse events, treatment clearly mentioned with according to their timing is very, very important. Then post-operatively handover record. So you can use iPass or you can use SBAR format, but you must have a properly recorded handover, especially when you're going to hand over the patient to the ICU or you're transferring patient to another higher center. Then Aldrich score is a very objective way of saying that the patient is ready for discharge. Now, the Indian Society of Anesthesiologists in 2024, I was a part of this committee. And so we have made a position statement for anesthesiologists. And I'm sure Dr. Meenakshi Sundaram is going to share that with you. But please go over it. It has very good templates for all documentation. So what we usually do not do is we do not document the dialogue or the discussion. So when we are giving pre-op instructions or when we are taking consent, when we are informing about any adverse event that has happened intraoperatively, when we are post-operatively giving NBM or ambulation and discharge information to the patients or the patient relative, we do not write what was discussed or whatever questions that we were answered. And in fact, who was present when this whole dialogue was going on. That there is a very important document that one must do, which is called safety netting. And this we must put up when we are discharging patients. So, for example, a patient has been given general anesthesia and ambulatory surgery. Then patient, if he has fever, if he has continuous vomiting, or if he is, feeling low, then he must report back to the hospital. So that is called safety netting. So you actually give them some warning signs that if these things, for even headache, after a patient is discharged from after giving spinal. So you can say that when you start having headache, if you have excessive headache when you're sitting down, please come back to the hospital. So that is called safety netting. So how should this clinical record be presented? So please assume that either a patient or the lawyer will read these notes at some point. So they must be clearly written, they must be understandable. And good handwriting has been now, even in the news, in fact, the courts are saying that they should include handwriting in the MBBS curriculum. So it has been, kind of highlighted so much. So good handwriting and short forms. And if you don't have good handwriting, then all prescriptions should go typed, because wrong prescriptions or wrong reading of prescriptions has caused many adverse events. Contemporaneous, and this is very important, that you write up your clinical records as soon as the event is over. Obviously, if you're having a cardiac arrest, you are not going to be able to write the document what you did at the time. But as soon as that event is over, or somebody else, you can actually delegate to write that, as because you want accuracy and you want clarity. Objective, that means they have to be factual. You cannot, imagine things. Attributable, who has given this information? Has the patient given this information, relative, or just a bystander? So that is also important. They must be all up to date, and each entry should be legibly signed with date and time. If you want to make a correction, suppose you know that you have made, you've not written something properly, do not try to erase the whole thing or put whitener or anything. You have to put a clear line across and write the correction, and then you can even sign that correction. So the original notes should not be retrospectively amended. Tampering, removal, substitution to improve the credibility of the original for deception and deceit, we will see later when we discuss cases, is a criminal offense. Patient confidentiality is becoming more and more and more important. So I want each one of you to pay special attention to this ethical and legal duty of the healthcare professional. So a patient is going to share his sensitive information with us in trust. It is our duty to safeguard all this information, patient identifying health information, and the core principle is that this information must not be shared with any third party without the patient's explicit consent. Now, confidentiality can be breached in 3 situations. That is, in reporting child abuse under POCSO, then reporting infectious diseases, and of course, under the orders of the court. So criminal proceedings, road traffic accident, mental status confirmation, when the court asks for them, then you can, even without patient's consent, you can release that information. There is also something which is called patient's privacy. Now, this is another right which is becoming very, very, difficult for us to actually understand. So this is the right of the patient to control when, how, and to what extent their personal information, which includes medical data, personal choices, is shared or accessed. So the importance of this is that it will be even more clear when I talk about digital documents. So medical records, whose property are they? So now the settled principle is that the physical or the electronic records, which are generated by the healthcare provider, they are held in trust by them on behalf of the patient. But the contained data in the record they are protected health information of the patient, and it is owned by the patient himself or herself, and only the patient can decide how to use that data. So in this case of Maharashtra, the Bombay High Court said that the doctors cannot claim confidentiality when the patient or his relatives demand medical records because they are theirs. So there is no confidentiality between you and the patient. So now the patient also has the right to get his documents. So the patient or his next of kin can apply to get their whole record. And the Indian Medical Council Professional Conduct and Etiquette and Ethics Regulation, they state that you have a period of 72 hours to give this whole document to the patient. But please remember that if there is a criminal case or a complaint to the police is lodged, the risk of documents being seized at any time is very, very high. So complete CPR notes and everything at the time of declaration of death, most of your critical event notes must be almost complete. Then storage and maintenance of records, actually, according to the Ministry of Health and Family Welfare, the DGHS has said that IPD records will be maintained for 10 years. Of course, OPD records for 5 years, and MLC records, they said, till the conclusion of the case. Now, but our NMC, that the National Medical Council, they only talk of IPD records and they say it has to be maintained only for 3 years from commencement of treatment. But now that digital records are coming into place, then it will be easier for us to uphold these standards of 10 years, conclusion of the case and OPD records, because maintaining physical records, retrieving them when a case comes up is really an unsustainable challenge. And the space required is just tremendous. So now what we have is that just like defense strategies have changed their form and shape according to the changing times, documentation also has to evolve to become relevant. So it is becoming digital. We call them digital health record or electronic medical record, because it's absolutely inevitable that we have to progress to that. So the central government and the Ministry of Health and Family Welfare is also pushing the Ayushman Bharat digital mission. So they want to give a unique health ID with a record from birth to death. So that is their ambition. And the CEA Act says comply with digital records. Electronic Medical Standards of 2016 are recommending digital records, and NMC 2019 advocates moving to digital health records. But let's understand what are their benefits. So what is their benefit? It overcomes all handwriting related errors and problems related to incomplete records, because what it does is that you cannot turn the page unless all the columns are filled, and there is a particular time before you cannot edit them after 24 hours. So there is a certain pressure to complete them in time, and they just will not allow you to close that screen unless everything is filled up. So, and the greatest advantage is that you can access it from remote locations, from your home, whatever, and you can look at it, but you cannot edit it after 24 hours. It has to then go through some higher authority. Now, it is very easy for retrieval for the patient to submit to insurance, employment, certification, and other doctors for any other consultation. And it's really easy to store and to retrieve even after years and years. And the most important, for which I think digital health record was made, was for efficient billing. because what they say is that if you have put a central line and you have not added it in your digital health record, you don't get paid. Now, digital health record has its own challenges for doctors and for patients. So there is a time pressure for completion, like I told you before. And so the doctor is constantly looking at that computer, like in this this picture, and there is no face time. So the patients are dissatisfied because they feel that the doctor is only busy, filling up that so now they have come up with AI summarization, but we have to be very careful when we are using AI because it might be inaccurate due to bias, due to autocorrection, due to hallucination, black box mode. Sometimes they don't understand what is being said because they're not trained on it, and then they may make a mistake. So it needs stringent human oversight for them to be reliable. So why I'm talking about this is because doctors are responsible for the accuracy of that record. So if you decide something on some wrong information, it may cause serious harm. So inaccurate entries. So you get a typo error. Okay, it keeps persisting in all the medical records. Empty fields get auto-corrected because you can't leave it empty, and then also careless selection. So there is an example which is given that the receptionist, she is told to ask certain questions. So one of the questions is, have you taken a tetanus shot? So a person comes with some injury during gardening. So the person says, have you taken a tetanus injection? And she says no, but there's a wrong selection and says yes. And this patient, actually, this is a true case which they give as an example for inaccurate digital records, and the patient dies of tetanus. So medical record is only as accurate as one can make it. The other major problem which is going to come up is in this digital revolution in healthcare, it comes with an increased vulnerability and risk of breach of this sensitive data because we are not safeguarding it adequately. So let's understand how this risk comes. So today we have evolved from gold to oil to dollars, and now data is the new currency. So you can see all this customer data, contacts, all this has become very, very valuable today. And what we are doing as doctors, we collect big data. We collect and store large volumes of patient identifying data. So they could be bank accounts, they could be personal name, they could be addresses, health related data, sexual inclination, race, caste, religion. Then have they given blood or have they received some transplant? And other biometrics also are being collected. So this is what we call big data. And this health record is now the most sought after by hackers and cyber criminals. Now they say that the health record fetches more money in the black or the dark web market than even the financial record. And that is because all patient identifying information along with the financial information you get in one place. So we've already had major theft of data of high profile Indians. India is really very, very vulnerable because we do not take safety very seriously. So it ranks second in the cyber attacks on the healthcare system. And we've had breach in AIMS data. We've got breach of the COVID data, where the chief officer Sharma, his own data was exposed via Telegram app. So it is going to be a major problem. And what happens is this exposed data, which is related to physical, mental health, organ donation, sexual inclination, this can be used to harm, to create violence, discrimination, threats, extreme social embarrassment. Today, in this era, Social embarrassment is becoming a very big problem. And this information is used for identity theft. It can be used for ransomware. And what is ransomware? Suddenly you'll find that your ICU, it just becomes, ICU data becomes inaccessible. And somebody will call you and say, pay this much, and then we will release this data. So phishing, malware, and the supply chains and third-party vendors are also targeted by the cyber criminals. So what happens is we have had very weak laws. So the IPC, the Information Technology Act, then Information Technology Rules, Clinical Establishment Act, and the Ministry of Health and Family Welfare. But now we have the Digital Personal Data Protection Act of 2023, and let's look at its healthcare implications. It is not healthcare specific. It does not apply to physical documents. The healthcare data is very sensitive data, and they have said that all sensitive data, the doctors are data fiduciaries. That means we are responsible for that for the safety of that sensitive data, and patients are data principal. So we are responsible for this data security. And if you look at the legal consequences, they are running in crores. Okay, so this is just if you violate failure to protect patient data, it's up to 250 crores. So it is really, really very, kind of the penalties are very high. And we are waiting actually for the data protection rules to come out. But the patients can also sue for damages in case of personal harm due to data breaches. And medical licenses may be at risk because of repeated privacy violations. So now she has not talked about video consent because I wanted to talk about it. So video consent is the best evidence of a consent taken and counseling done. But now what you need to understand is it has to be done in a proper AV room. As far as possible, do not do it on your phones. The consent, you need a consent for recording, its use and release. So you must tell the patient that I'm recording this conversation. And what is it going to be used for? So you can say that it is for medical legal purpose. Some preparation needs to be done because, you need to get used to what question, how to answer their question, and, and what information to give. So you need this infrastructure to record and to save. Because if you want to retrieve this information, then you have to actually prove that it is true. It is not AI generated. You need 65B certificates, timestamps, geotags, hashes, and metadata. So this has to be given. You can't just make a PDF of your of this consent and give it to the police or to the law, in the court. So this is, I think, one of the most important slides of my thing. This is data protection measures because stakes are high. And I think the young people are using so much of this digital, practices. So what you need is really very good data protection measures. So first thing I will say, avoid public Wi-Fi for sensitive information sharing. Do not keep any patient data on WhatsApp. Always remember that AI tools or services that you use, they are using your patient data for learning purposes, and this vast data collection is mostly unregulated in India, and it's liable for breach. So we need to have good, contract with the vendors that they will give us security, keep software updated with the latest security patches, put passwords, and whoever have entry into that computer, it must be a logged in entry. So you know who was the last person who used this monitor or this machine. So do not keep it open for everybody. So this is what I said, that authenticity of any electronic document, mere digital printout is not enough. You need those other documentation to just say that it is authentic. So let's just look at a few case laws which are related to documentation. So in this case from Apollo Chennai, CPR notes were not written and res ipsa loquitur is held. What is res ipsa loquitur? Means you do not need to prove anything. It's just that CPR notes are not written. That itself has been taken as negligent. And look at the compensation, 57 lakhs around. And this is 2018. Now you will see how the compensation increases. So now this one, patient underwent laparoscopic hernia repair and it was done under GA. The surgery took 5.5 hours. The patient remained unconscious for 2 hours post-op. And then he was shifted to the back. He was shifted to the ward, again shifted back to the OT, and then he was shifted to a higher center for ventilatory support because he remained semi-conscious. He went into coma, and then he was hospitalized for almost a year, and then he died. So what was the deficiency? It was that no documentation of what was the cause of this delay. Why did the patient suffer hypoxic brain damage post-operatively? So that was not clarified in the document, and the hospital surgeon and anesthesiologist has been held negligent. This is a paltry amount now. If you see the rest, this is 15 lakhs has been awarded. Now, in this case, look at how important history taking is. So there was a history of allergy, but it was not taken into account. And the patient was given an antibiotic, which was ceftriaxone. And he went into anaphylaxis. They could not revive him. And then he also has gone into a vegetative state. And then look at the punishment. So this is a private medical college, 51 lakhs of compensation and 75,000 per month to be paid to the kin for upkeeping of that patient who has gone in a vegetative state. This is very, very important. I told you safe surgery checklist is a very important document. This is a 2016 Fortis hospital. So very, very, upgrade hospitals also can have error. So they operated on a 25-year-old patient on the wrong leg. And then they started saying that, both were injured and, trying to say that, there was no mistake, we were just checking, whatever. And the Delhi Medical Council has taken a suo moto action on all the doctors involved. Now you can see 5 Fortis hospitals, they have been sacked. One of them is 100% an anesthetist. Now what the anesthetist gave as defense was that I gave spinal and then I was busy. Can you really say that? No, because the courts are saying that you are all working as a team and you are all responsible for safety. So this is something that you must get involved with, and please see that it happens every time you take a patient in. Now, this is also a thing, doctors told to pay 33 lakhs for a patient's death. And so the intraoperative monitoring. So they were doing a laparoscopic removal of a very benign tumor. The patient has a sudden collapse and dies. So the differential diagnosis which was given was that it was embolism. So that was given by the anesthetist. But the court said that there's no document to show the monitoring of ETCO2. So the documents fail to show that diligent effort. They also fail to show that they have made diligent efforts during the treatment or resuscitation, and 33 lakhs has been awarded because incomplete document. Now, this is a very, very interesting case. I just have 2 more slides, sir, in case I'm getting late. So this is what is in this case is a 2010 case. This is from So the patient was admitted for a planned LACS. This is the patient, and she was to be given GA that because there was no spine deformity. There was a spine deformity. So on induction, the patient has a cardiac arrest and dies. The anesthesiologist's notes say that this was due to allergy to thiopentone. Now they send this patient for post-mortem, and the post-mortem shows fractured pelvis with a large hematoma, a liter of blood in the abdomen, and this is most likely due to a fall from the operation table. So the National Commission has held that this is fabrication of documents and a whole cover-up by the hospital and the anesthesiologist. And look at the compensation: 1.6 crore compensation to be paid by the hospital and the anesthetist. So there is a very wise saying which says you alter the records and you lose the case. There is a similar case, very, very famous case, very old 1997 case, but I would like to talk about it. What happened in this case, it was it was like doing the headlines for a long time because Dr. Karnataka Dholakia was a very famous orthopedic surgeon. So he was doing a spine surgery, and the patient was a very well-known industrialist's son. And what happened was that they turned the patient, and then the surgeon said that the patient is blue. By the time, and what had happened was that the endotracheal tube had got disconnected, and the patient, by the time the patient was turned around, endotracheal tube was reinserted. The patient suffered from hypoxic brain damage. In 1 hour, they had to declare the patient as in coma, and the relatives were very, very influential. So they went to the police station, and what they did was they called every person from the theater, and each person was asked what happened. What the anesthetist had written in his notes was, this is allergy to scoline. Okay, and every person, that means from the ward boy, every person was called to the police station and was asked what happened. And of course, then the truth comes out. And they said that the endotracheal tube had come out. And what the judgment says, that it's all right if the endotracheal tube comes out, but you have not mentioned it in your, so you have omitted information, you've given false information, you've caused evidence to disappear. So this is a cognizable and bailable offense. So this is another important case which I would like to tell all the people who are using social media so much. So sharing of patient identifying information on social media is a crime. So please see the very innocent act of just sharing. The patient had undergone C-section, patient delivered triplets. The anesthetist took pictures and shared them very widely on social media. And by evening, he was booked under all these sections. Today, it would be BNS 77. This is called voyeurism. And this was September 23. This is August 24. The patient, the FIR is yet not squashed. And please understand, in any adverse event, in criminal cases, if an FIR is found, the first thing they will take away is your mobile phones, and they will start, seeing what you have kept. So please don't keep any patient information on your phones. So you can see the importance given to documentation by our courts, and compensation awarded are going into crores. So any tool that you use to create medical records or documents must be used very wisely with a clear understanding of its limitations, legal and ethical challenges. Thank you, sir.
Yeah. Thank you, Dr. Prathipa. As usual, it was a wonderful presentation and covered everything, okay, including the technologies and AI are in due course of time, where exactly how vigilant you should be there pre-operatively, intraoperatively, post-operatively. And you cannot record just like that. Just a video or mobile is available in your hand. Intraoperatively, many anesthetists are used to that. Okay, the surgeon insists to take the photograph and anesthetist and he forwards it. So that's
And then
what
you
routine is
forward
happened.
it.
But
Yes.
yeah,
So
we
that is
forward
the
it.
problem. That
Yeah,
is the
that's the
problem.
problem. And it's a very interesting because Madam, she has cleared a lot of ambiguities, okay, in the documentation, other things. But as you rightly said, video consulting, there are certain loopholes probably Indian doctors or Indian medical technology needs to overcome that hitches, just like a hacking, data breaches, and technical glitches also there. And infrastructure expenditure also important for that. Probably most, unless there are corporate hospitals, many small and medium-sized hospitals may not be able to do such things. And there are certain limitations also, which I have briefly told how exactly we can overcome the glitches or information technology. And few of the documented cases, okay, they are really eye openers, and especially practicing anesthesiologists should be aware of those things. Otherwise, we are going to be in a soup. Especially that's what Pariksha Dalal versus Santosh Hospital, madam rightly said. Okay, and there are some documented cases where the anaphylaxis can occur pentatal, but anaphylaxis due to pentatal can never cause a fracture hip or hematoma. So anybody can say that it's only because of the fall from the OT table or whatever it is, or before the induction or soon after induction, and they cannot escape. Okay, that I would say that again it falls in the risk ships are located. So especially preservation of the documents, madam rightly said. Okay, few states have their own SOPs. Okay, how exactly they should preserve the documents and destroy them. Okay, and especially Consumer Protection Act, even in recent amended act. So documents have to be preserved for 2 years. But what happens if the patient or patient relatives, okay, and they apply the condonation application? So probably it is the whims and fancy of the consumer members and president. So to allow the filing of the case. So as she rightly said that at least for the indoor patients has to be preserved for 5 to 10 years. So as she said, for MLCs, yes, once the case is as a medical legal case, it has to be preserved as long as it is dismissed, whatever it is. But data privacy has come into picture, and you can store them in the computer. So if there are any questions, we'll take it afterwards. It's already 7 o'clock now. Dr. Meenakshi Sundaram has said it will be better to wind up on or before 8 o'clock. So may I request Dr. Krishnamurthy sir and to go with his deliberations, please.
Yes, sir. Thank you, sir.
Yeah.
Thank you for the nice introduction, nice words. I am glad to observe that this program, Puthukkottai Bhudhan, is going on very strongly, both in terms of the number of programs organized so far and also in the number of attendees taking part in the conversation. This presentation is about professional negligence in general, not going into the particular features of the law of negligence like consent or documents or other things. And I'm going to deal with this general legal concept. And I'll be considering why should doctors know about professional negligence? What is their profession? What is negligence? And much more important, what is not negligence? See, today we are living in an era of litigation. Not a day passes without a doctor or a nursing home getting dragged to the consumer court. And as Madam Kane rightly pointed out, in many cases, it is not because doctors were found lacking in skills or competence. It is because there were some legal defects, either in the document or in consent or in other aspects of medical care. See, law wants certain things to be done in a certain way, and we have to do those things in that way in order to steer clear of legal problems. And luckily, the legal requirements of medical practice are not very difficult. They are very easy to follow and they can be easily integrated into our practice. Unfortunately, this litigation cannot be entirely eliminated, though the incidence can be brought down considerably by following all the legal norms. First of all, there is a law which permits litigation. Naturally, people want to take advantage. You cannot blame them. The procedure is very easy and multiple avenues are available for litigation. A patient aggrieved by medical negligence can go to any of these forums or all of these forums or one by one successively, making your life hell. And the procedure also is very simple. No money is required to be paid, provided they have spent less than 5 lakh rupees for treatment. They don't have to pay any money. And in the CPA 2019, there are one or two adverse features. Patients do not have to pay any fee for filing an appeal. A doctor has to pay 50% of the decretal amount awarded as compensation. And there is no penalty for frivolous litigation in the new act. In the old act, there was a provision up to 10,000 rupees could be imposed, but even that has been removed. And some of these health legislations, PNDT Act, CE Act, they contain many anti-doctor provisions. For a simple error in record keeping, your ultrasound machine could be seized. In a polyclinic where many people are practicing, if one doctor gets into problem, the entire clinic is sealed, affecting the livelihood of all the other people also. So the only way out is to incorporate legal mandates into practice. Like for example, say law says consent forms have to be signed not only by the patient, but also by the doctor, and they must be witnessed by a third party. Likewise, all these legal conditions must be fulfilled, and we must also observe the ethical guidelines of medical councils. In short, we practice our profession in such a way that we satisfy both the patient and the law. Now, what is a profession and what is negligence? See, human efforts to earn money can be divided into 4 types: business, trade, occupation, and profession. Business means just buying and selling. Anything can be bought and sold. So, business deals with a wide range of articles. Trade means a special kind of business dealing with only one article, like, say, gold merchants or iron merchants. Generally, these people have an extensive knowledge about the article with which they are dealing. Occupation means any way of earning livelihood, offering services for money. It can be short term, long term, temporary, or permanent. Educational qualifications may be required for some occupations. Technical skills with or without education may be required for some occupations. Coming to profession, profession is a special kind of occupation requiring long years of education, experience, and technical skills. After completing the education, we are required to register with a regulatory body established by law in order to gain membership and a license to practice our profession. A code of conduct regulates our function on pain of punishment. That is, if you violate the code, you are liable for punishment. And we are charged with the duty of care and responsibility towards patients, the society, and the law. Generally, professions carry a high social status and prestige. What is negligence? Negligence has been described as a state of mind, a careless state of mind. If you want to throw something through your window, first of all, you must be very sure that there is nobody behind that window. If you still do it, then it is negligence. That is, you're not taking care to verify whether there is somebody there. So it's a careless way of doing things. It is also described as a careless conduct or conduct resulting from the state of mind. So negligent person is a person who does not take adequate care in his activities, even though he has no intention to do any harm. And he allows his attention to wander, does not focus, does not concentrate on the task at hand. All these things lead to errors and problems, which sometimes may cause harm to others. For the doctors, there is an additional criterion where the law has prescribed a standard. Failure or inability to measure up to that standard will also be called as negligence. And we all know that courts follow this average practitioner standard in adjudicating cases. If you don't measure up to that standard, then you are called negligent. If you analyze our medical profession carefully, you will find that doctor plays 3 roles. First and foremost, as a human being who has received the benefit of medical education and belonging to a noble profession, he is charged with ethical duties and responsibilities. This is his ethical role. Number of ethical responsibilities are there for the doctors, like confidentiality, duty of disclosure, beneficence, non-malfeasance, etc. So those duties have to be observed. This is his ethical role. And he is also a doctor who has been given some privileges by the society because of his profession. And that is the legal role. For example, doctor can issue certificates, he can issue prescriptions, he can enter courtroom appearance, he can do vaccinations, he can interact with the healthcare authorities. These are not available for other people. So this is the legal role. And finally, during the medical care, he acts as an healer and a care provider, using his special knowledge, experience, and his skill. This is his clinical role. Negligence may occur in any one of these segments or in all the segments. Now, the first category is ethical misdemeanor, where you fail as an upright human being charged with the ethical duties and responsibilities of our profession. These ethical duties and responsibilities are given in the Professional Conduct, Etiquette and Ethics Regulations 2002 by the Medical Council of India. Recently, the National Medical Commission has also come out with its own set of regulations, the year 2023. They are much more elaborate than the one given by the erstwhile Medical Council of India. All of us must know it and follow it in our practice. Some examples of ethical misdemeanors are rude or discourteous behavior towards the patient or relatives, misleading qualifications. You are only a general MD physician, but in your prescription pad, you say that you are a physician and cardiologist. Accepting gifts from pharma companies and using substandard products, practicing beyond qualifications, issuing advertisements which glorify your institution or your capabilities, not maintaining medical records, inappropriate contact with the patient or relative. These are some of the ethical misdemeanors. Generally, because of ethical misdemeanors, no physical harm accrues to the patient. There may be some mental irritation or displeasure, and these have to be agitated before the medical council, state medical council, or the National Medical Commission. And the punishments are warning or suspension for varying periods, depending on the gravity of the offense, or permanent removal from the register. The Delhi blast doctors have been permanently removed from the medical register. The second category is failure as a doctor belonging to a profession which has got some standards. So failure in the integrity of the profession and is what is expected of a doctor belonging to a mobile profession. This will be called as a professional misconduct. These things also have to be agitated before the medical council, state or national. Some examples are issuing a false certificate or giving false evidence in court, tampering with medical records, or refusing to help in an emergency on the basis of caste or religion or other considerations. There is some overlap between ethical misconduct and professional misconduct. For example, doing a surgery without informed consent will be a breach of ethics, because as a doctor, you are supposed to give information to the patient about his condition, about the surgery, about other things. It is also a professional misconduct and also a medical negligence. Some instances of professional misconduct can turn out to be criminal offenses. For example, issuing a false medical certificate. Using that certificate, a person may dodge a courtroom appearance or he may dodge a warrant or summons. Then it becomes a very serious matter. Similarly, giving false evidence in court. If because of your false evidence, somebody is sent to the gallows, then it is a very serious offense and it attracts very heavy punishment. Tampering with records is forgery, again a criminal offense. And now we come to the third category, that is medical negligence, not possessing the requisite qualification and skills. See, you are only MBBS doctor, but you practice diabetology. Or failure to apply the knowledge and skill you have due to various reasons, fatigue or intoxication or whatever, or failure to provide a reasonable degree of care. During the surgery, the anesthetist goes for his next case, leaving the charge to some junior person. Or during the post-operative period, the surgeon escapes. He goes on a vacation, leaving somebody else in charge. All these things are failure to provide a reasonable degree of care. Some examples are failure to monitor the patient, delay in diagnosis and treatment, mismatched blood transfusion, operating on the wrong patient, the wrong limb, wrong site. All these things will come under medical negligence. Now, how is it adjudged? How is medical negligence decided in a court of law? The procedures we call it is summary trial. It's based solely on documentary evidence. the affidavits that we submit, which contains all our pleadings. And the standard of proof is called preponderance of probability. See, both sides give evidence. Both the patient and doctor give evidence. Which side evidence is more natural, more stronger, that side will win the case. So it's called a preponderance of probability. And legal representation is allowed in some cases, or you yourself can argue for yourself, called party in person. Expert opinions can be brought in, and standard textbooks can be referred to. By a combination of all this, the negligence of a doctor is established. Now, who decides negligence? See, contrary to popular belief, it is not the judge. He only announces your negligence in the open court. It is only the punishment part which is the prerogative of the judge. But negligence is decided by our own professional standards and our failure to meet that standard. Our fellow brethren who establish a standard in a given case. So these are the people who are directly saying that you are negligent. And who proves negligence? It is the patient, naturally, because he is the one who is going to the court asserting that you are negligent. So according to the Indian Evidence Act, one who asserts must prove. So naturally, the onus falls on the patient. But there is an exception here, where the negligence is very obvious. Example, patient came to you with gangrene of the right big toe. By mistake, you have removed the left big toe. Or a patient came for cataract surgery on the right eye. You have operated on the left eye. In these cases, the negligence is very, very obvious and requires no analysis. And in these cases, the patient will not have to prove anything. You will have to prove your innocence. So, what are things that are required to be proved? Patient has to prove that first there was a relationship of duty between you and the patient. That is duty, and patient has to prove that doctor breached the duty, and because of that breach, that particular damage or harm has occurred. In addition, he has to prove regarding the damage, he has to prove proximity. That is, the act, negligent act, and the damage are related in space of time. For example, you give a spinal today. A few hours later, patient wakes up with neurological deficits. So there is a proximity. And it should also be foreseeable. There should be a causal connection between the negligent act and the damage that has resulted. Doing a neurological intervention and neurological deficit is foreseeable. But you do a spinal today, patient complains of itching in the back of the neck. That's not a foreseeable problem. And but for a test, the patient has to prove one particular act which contributed to the damage. So all these things are required to be proved by the patient to establish medical negligence of the doctor. Now coming to the duty situation is very important in medical legal cases. Generally, we owe a duty to others who are affected by our actions. As doctors, we affect our patients, so naturally, we owe a duty of care to them. This duty must be of a legal character, not a moral or religious duty. And where there is no duty, there is no negligence. It can be something else, but it will not be called as negligence. So, to give you an illustration, say, assume that you are an expert in swimming. You are taking a walk along the beach. You find somebody drowning and crying for help. There is no legal obligation on your part to go to the aid of that person. But if you are a lifeguard posted there, then it is your duty to jump to the aid of that person. So duty situation is very important. And regarding breach of the duty, we already said that breach of duty is determined by applying the standard of an average practitioner of the same specialty. What another equally qualified competitor would have done for your case, for that particular case, for that particular surgery at that particular time. That is the standard that is taken as a yardstick. And your activities are measured up to that standard. If you reach up to the standard, then you are not negligent. Luckily, law does not require the highest degree of care or skill or expert knowledge. Coming to the damage, damage is the harm that results to the patient, and damages is the compensation awarded to the patient. It is not the plural of the word damages. Damage. So where there is no damage, there is no negligence in tort law. A patient cannot go to the court saying that you are negligent. And negligence must be the proximate and efficient cause of damage. It must be the causa causans and not the causa sine qua non. Causa causans means the primary cause contributing to the harm. Causa sine qua non means the accessory or subsidiary causes. Again, I will give you an illustration. See, supposing a small child, say a 4-year-old child, is walking on a lonely road on a rainy day, it falls into a drain and drowns. Here, the causa causans is the drowning, but the causa cinco no is the negligence of the parents in allowing the child to walk without any unaccompanied. This case is a landmark case in the law of medical negligence. The judgment given in this case is an epitome or a synopsis of the law of negligence. So I will read it out. A person who holds himself out ready to give medical advice and treatment impolitely holds forth that he is possessed of the skill and knowledge for the purpose. Such a person, when consulted by a patient, owes certain duties, namely a duty of care in deciding whether to undertake the case, a duty of care in deciding what treatment to give, and a duty of care in the administration of the treatment. A breach of any of these duties gives right of action of negligence against him. Medical practitioner has a discretion in choosing the treatment which he proposes to give, and this discretion is wider in case of emergency. It's about the Bolam test. But he must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care according to the circumstances of each case. Now we come to criminal negligence. See, generally, negligence is a civil offense, is a tort. It is untried in ordinary civil courts, but sometimes it can also be a subject of criminal law, where gross with the negligence is of a high degree. It can be considered as a criminal negligence. So, criminal negligence is gross negligence or unconscionable degree of negligence, where you show utter disregard for human life or taking a risk knowing that there is a risk. For example, there is a difficult airway situation. You have neither procured any difficult airway gadget or you have not taken any help. So that would be criminal negligence or something that other doctors would never do is also a criminal negligence. Some examples are operating under intoxication, OT without anesthesia, surgeon is doing a vaginal hysterectomy, he himself gives the spinal and proceeds with surgery. That's criminal negligence. No adequate stocks of oxygen in the theater or no resuscitation equipment. You are doing cardiac surgery, but no, the defibrillator is not functioning, abandoning the patient. Midway during the surgery, anesthesia escapes for his next case, or midway in the post-operative care, surgeon escapes for vacation. All those things would come under criminal negligence. So if you cause death by negligence, according to section 106 BNS, it can be imprisonment up to 2 years and shall also be liable to fine. That is, you will definitely get a fine. In the previous act, IPC 304A, it was imprisonment up to 2 years or fine or both. So there is a worsening here. Causing hurt by negligence. If you cause hurt by negligence, that comes under section 125 of BNS. Up to 6 months imprisonment or fine up to 5,000 or both can be given. If you cause grievous hurt, if you remove the wrong eye or wrong limb, up to 3 years imprisonment or fine up to 10,000 rupees or both can be given. And we'll see what is not negligence. A simple error of judgment is not negligence. Or failure of treatment. Every medical treatment cannot end successfully. There can be failure sometimes due to various causes, but that would not come under negligence. Unsatisfactory outcome is not negligence. Known or inherent risk of a procedure is not negligence. If complications occur despite due care, if you can demonstrate, if you can prove that you have provided the despite due care, then even the complications, including death, would not come under negligence. So the lessons we draw from the foregoing is the law is very simple and clear. It gives consideration to the safety and the well-being of the patient at all times to the exclusion of all other considerations. That is the primum non nocere. Do not do harm. It is all right if you do not improve the condition of the patient. It is all right if you do not give any cure or relief. But by your ministrations, you should not introduce a new element of suffering. That's what it says. The legal mandates in medical practice, the legal norms are very simple and easy to follow. No effort or expense is required. They can be easily integrated into our practice. And because our profession is a noble one, it is a duty of all of us to follow all the ethical norms of our profession. Thank you very much for your patient hearing. Thank you. Thank you very much.
Yeah, thank you very much, Dr. Krishnamurthy sir. And it was a wonderful talk. And you have covered basics of what exactly is the medical negligence, more so anesthetist, and what is the consumer laws of 2019. And you touch upon even the BNS 106, grievous hurt, and other things. That's very nice presentation. And yeah, complications do occur, okay, but if you don't diagnose them in time, and if you don't take any measure to prevent further harm being done, definitely, as you said, it's a reckless on the part of the anesthesiologist. So many times I've seen the young anesthesiologist, probably we don't know, probably we are also doing the same thing when we were young. We have to be very, very cautious. And anesthetist, even I think probably I would urge all the younger anesthesiologists who are very busy having a multiple cases at a time, probably refrain yourself from using the mobile phones instead of OT unless it's a mandatory. So there is a one case in Texas. Okay, the court verdict was treat but don't tweet.
Yes, sir.
A 60 years lady who was
Yes.
going for a low cardiac risk procedure,
Okay.
and after the 15-20 minutes or something like that, patient had a cyanosis and bradycardia, had arrest. And anesthetist said that yes, it's a known complication. But when they retrieved everything, surgeon was able to tell that he was on iPod for the last half an hour. He never bothered to see till the patient becomes cyanosed. So such things do happen, but somehow we'll try to shift our responsibility on the hospital or surgeon, whatever it is, which you are not supposed to do it. Thank you very much, sir. Even in the BNS, as you rightly said earlier, okay, 304 year, either there was a 2 years imprisonment or fine or both. But in BNS 106, whoever causes death of any person by doing any rash and negligent not amounting to culpable homicide shall be punished with the imprisonment of 5 years and fine. If the same is done by the registered medical practitioner under the respective medical council of the NMC, the imprisonment is 2 years
2 years.
and the fine. This is the just probably I would say that leniency is given to the doctors, unlike other specialties or the truck or lorry drivers or whatever it is.
Yes, sir.
So I think I must congratulate all the three for presenting a wonderful topics and making it very simple. And most of the times we do come across the conflicts between anesthesia and the surgeon, and wherein anesthesist is reluctant to give anesthesia, but in the meantime surgeon says that yes, we have taken a high risk consent, or else we have taken a grave risk consent, or else still more they say that we have taken death on the table. So this we have as a risk consent formula. Probably they would fall into the category 4 or whatever it is, but there's nothing like a grave risk or a death on the table consent. I have not heard of it, but still surgeons, it's very difficult to convince them. That's what even Dr. Pratipa also will agree with me. There's nothing like hand death consent or the grave risk consent. So where the risk of mortality is more than or double than the average persons undergoing the same kind of a surgery, probably it would fall in the ASA grade 4 risk. But it's not like death on the table consent. So anybody can throw light on this? Probably if there are any questions.
Can I just say something on the
please,
death on table consent? So basically it is considered bad in law that you should want the patient to say that I'm ready to die. So the principle here is that you take consent for that 1% chance of life rather than that 99% risk of death.
Okay.
And if there is 100% risk of death, it's best you don't touch him.
That would be the correct approach. Especially in these days of litigation.
And even the death on the table, I came across one case. The judge, how can a patient willing to die on the table, having known that he's going to die?
Yes,
the other one is probably it is against the public policy or the inner contract law also. Okay. So I appeal to all the surgeons and anesthesiologists, don't yield to the death on table consent. Okay. And the grave risk consent, it just falls in the ESA grade 4. That's it. Okay. Where the like a mortality is more than,
And we can say that there is high risk of a cardiac arrest. There is high risk of, going on ventilator. There is high risk of all this. But death on table is
Yes,
very
madam.
poor.
Yeah.
The
And,
word
and
death,
even if the patient refuses or related refuses for the consent, you must record it. I think probably you will agree that there is a case in Kerala, Elisa case, where the surgeon was he did not operate because the patient or relative did not give the consent, and ultimately patient went to the acute pancreatitis septic and died. And he said they did not give the consent, so I did not operate. But the court show me where they did not give the consent.
yes, sir.
Okay,
It
they
was
have
not
not given.
recorded.
Have you documented it? He has not
Yes.
documented. So ultimately, it's put that the anesthetist or surgeon was negligent while not operating in the emergency.
The similar case has happened in Delhi, where
Yeah.
that 1 crore compensated. The patient had a very prolonged labor, and a CP child was delivered. And the gynecologist said that I didn't get consent. And so the court has asked this, show us when you took consent, when you asked for consent, and when did the patient refuse. So they could not do that. They could not find any thing to say that the patient has refused.
Yes.
Yeah.
Madam, this is a common scenario, madam, in our part of country. The young mother wants to wait for her father-in-law or husband to come. And that fellow comes only after finishing his office work. So what happens is a few hours of delay invariably occurs, and that worsens the condition of the baby sometimes. As you said, madam, we have to record the time of
Asking for consent.
yes, asking for consent, and when actually they signed it.
And one more for the anesthetist colleagues, PA is very, very important. Okay, never ever neglect it. Here, see, even if you spend about half an hour, it's a late night, also nothing wrong, and seeing the patient, looking at the report. However, it's the AS grade 1 and grade 2 is there. Just document yourself that PA was done and the reports are acceptable. ASA grade so and so. I think probably everyone will agree there is something like Annaben Kotaria versus Navdeep clinic, wherein anesthetist was reluctant, okay, to give anesthesia, but ultimately, orthopedist suggested that no, I have taken an opinion of the cardiologist. Okay, intraoperatively, patient had a cardiac arrest and he did their best, could not be revived. So it is supposed to be subject to the postmortem because cause of death was not known to the anesthetist also. Even a surgeon also, even for the cardiologist also. But to hatch up the things, the cardiologist himself declared death and he gave a cause of death. So when it went to the court asked the anesthesiologist only one thing. Okay, ECG was showing STT changes. Probably they're specific or non-specific. Since it was an elective case, why did you not subject him for the further evaluation? He said that I relied upon the cardiologist report. They asked, you are a qualified person. How can you rely only upon them? So automatically, in those days, there was a 4,25,000 for which anesthetist was shared 60% of the compensation, 30% cardiologist, and 10% of the surgeon. So if you are sure that case cannot be given and unhandled, straightway you bring to the notice of the surgeon that we cannot handle it, I cannot give the anesthesia. You may lose 1 or 2 cases, but it helps you in a long way throughout the profession also.
Requires a lot of courage, sir.
Yes, sir.
Sir, as there are no questions in the chat box, that means people are not even ready to ask questions because they don't know what is medical negligence. That is the idea to sensitize, because if it is a subject, they would have come when thiopentone is contraindicated, what is the dose of propofol? But now, what is the dose of compensation? Nobody will ask. So, just to throw open the discussion, because you are legal luminaries, I want to ask a few clarifications so that you can elaborate, which will be beneficial for everything.
Yes.
The Prabha Manchata case, Dr. Rutukja explained. Even I was about to check, but I have not checked. So I think it is better to listen than to read. See, I was told that in that it is mentioned if there are 10% chances of complications, then only it should be informed to the patient. Because as Dr. Prathipa Madam pointed out, see, if you explain like death on table, the patient will run away from surgery. The Supreme Court has clearly mentioned, I have read that, see, the patient will seek alternate modes of treatment. That should not be done. See, the court, they are using some gray areas. Even now, in this ICU, we have seen the formulation of code of conduct. See, they say qualification in anesthesia or pulmonology or surgery or general medicine or 3 years of extensive research in ICU with 50% of the time spent in ICU. This is
Yes.
the qualification given by the court. What does it mean? See, 3 years means then everybody will get a certificate. Then 50% of the time in ICU, I don't know how they are deciding that. How we can say 50% of the time is spent on ICU? Because the court want to interpret like severe injury, gross negligence. This gross
Yeah.
severe is decided by the judge. So we have to inform our younger colleagues, please don't argue within the IMA hall or ISA hall. If at all you, because every time I am seeing, they will shout at me only, sir, how we can record the findings, sir? When the patient is brought in casualty in a severely injured state, how you expect us to see? They will dramatize everything, but we have to sensitize them. It has to be argued in court, not in air-conditioned IMA or ISA halls or in any of the conference.
With the
That is
judge.
what. So I want your point, whether it is rightly said it is more than 10% of the complication, then only it is informed to the patient. Because I have not checked. I want you
Yeah.
people to say whether it is true or not.
Yeah. Sir, yeah, there are two things. One is a relative risk, subjective risk, and remote risk. Okay. So relative risk of only 1 to 2%. The chances of having cardiac arrest on the table need not be told to the patient or relatives. If the risk is relative, probably it's more than 10%. We should bring to the notice of the patient, and it should be written on the consent also. We should bring to the notice, no doubt about it. I think probably.
Sir, whether it is written in the judgment, I am asking,
No.
because the judgment is running to several pages.
No,
How
Yeah.
to read
no,
where it
sir.
is? Because I was told by that obstetrician who is a leading lawyer, obstetrician, male obstetrician with a legal background. He is arguing cases. I have forgotten his name. He is from Maharashtra. He only told me in the conference, I asked specifically, he said the court itself has mentioned if there is only more than 10%, then this percentage who will decide? Even that
Yeah.
percentage. So everything
It
is
is
very difficult. And I want to know, I want to ask one more question to legal luminaries. See, we say whatever complications occur, the hospital or the doctors are not responsible, we are getting. Whether it is having any validity in the court?
no, sir. So you
No,
cannot
sir.
take away the patient's right to sue. So you even
Yeah.
whatever you write before that we have informed and we have no complaints against it. That
He
is
can
not
still
a
knock the
valid.
door of the justice.
That is
Because
not valid.
I want to ask, whenever we leave the car in the parking area, they will be mentioning in the ticket, if the car is broken, if the light is stolen, if the steering is missing, we are not responsible.
You are not
Whether it
responsible.
is true for medical fraternity also, that is
You
okay.
cannot take away the patient's right to
Right.
sue.
Oh, then you have to defend.
Madam, I
Suing
You have to
myself
right.
defend.
have one question. Can we have a waiver agreement with the patient after the incident has occurred? Okay, after death or cardiac arrest, whatever. I enter into an agreement with the patient wherein patient surrenders his right to sue for a monetary consideration. Is
Whether
that
it's
possible,
right,
madam?
that's what I'm asking. If it is so,
Yes.
everyone can do that.
Sir, I have done it in one case, sir.
Yes, sir.
Sir, but
Oh.
that you mean that is like out of courts kind
Out
of
of
Yes,
court
settlement.
madam.
settlement.
Yes, you're right.
But out of court settlement, they can yet go back to court. Now it's good that this person has
That's
not
what.
done it.
Sir,
They
there
Sir,
are
can
three
another
go
one,
things,
back.
sir.
sir.
Madam, in
Yeah, I do
the
agree. Out of court settlement is there. Okay. For example, earlier it was not there in 2019 CPA. There is establishment of the mediation
mediation.
cell at the district, state, and national. If the both parties agrees upon, because doctors also knows that he cannot win, and patient also knows that he is going to win, but it takes a long way. He doesn't have money to pay the lawyers. So if
Yes,
they
madam.
come to the mutual agreement, they can forward an application to the president. If the judge decides, they refer it to the mediation cell, and the mediation cell, since it is a voluntary agreement between the both two, they pass an order. That is valid. None of them go appeal for that. So this can be done. But
So the
when it
mediation
comes to the
rules
Sir, one
yeah,
thing,
very
sir,
clearly say that medical negligence is not amenable to mediation. So death is not amenable.
sir,
death is
as
not
a
there. Death is not
layman,
there.
sir, as a layman, I'm
So
asking a question. When there is a mutual agreement, why we have to go for a mediation cell? Already there is
Sir,
a mutual agreement.
no, if the case is already filed in the case,
So
Yes,
he
even if
decide to go
the
for the mediation or a settlement, he can as well do it.
you
Okay,
can't, sir.
and
Now,
but the pre-litigation itself, you can settle out of court. Pre-litigation before filing the case.
Not for medical negligence. So the rules are very clear that medical negligence is out. In fact, there is now we are trying to put a petition.
Death and the grievous injuries, they are exempted from the mediation cell.
Yeah.
In the Dharwad as a mediation cell member, last month only I have settled one case.
No,
It was
that
not
is
a death
okay.
or the grievous injury. It was something like they had some grudge over the doctors, and
Then
we could
that
take it
is
30.
different.
Yeah,
But
not
usually
the
it is
death or the
because of
grievous
death.
injury.
Death
Not the
is
death or
not.
grievous injury.
Madam, 1 second. Whatever it is, if they are going to the court, they will get more compensation. But as sir pointed out, some people will think now what these people are doing. Most of the time, the third party is not a legal person. Just like a thug, he will enter. He is going for local. That is a mutual agreement, right? You
Correct.
this much gives this much. So when there is a mutual agreement, I don't think that we have to go for mediation. Even now, even when the case is on, if we are on mutual agreement, then either he will not press the case or he will withdraw the petition. That's what even in
He has to then withdraw the petition, and
that is
only
important.
then you have to pay the money, sir.
Madam, the public interest litigation, Madurai bench of Madras High Court has mentioned, you are filing PAL, you are collecting some ransom money, then you withdraw the petition. So they have refused to allow the withdrawal of petition now, a day before yesterday.
Okay.
They have not allowed a PAL. You cannot sue for PAL and you cannot withdraw the petition. So like that, as you said, only after his withdrawal we have to pay the money.
Yes.
Again,
Yes,
he will say,
definitely.
only if you pay the money, I will withdraw.
Yes.
That is the problem. That is the problem. Yes.
But it's a very precarious situation, sir. What happens is he withdraws in the consumer case or out of the settlement. After having taken money, again he can go to the police
Sir,
station.
then
Medical
I want to
counsel.
ask one more question, sir. Sir, I want to ask one more question because for the favor of delegates, I am asking the question. Can at the same time, take some example, a government doctor is getting caught in medical negligence. Whether he can move simultaneously the Medical Council of India, he can move the dean or joint director, he can move the consumer court, all the three, whether they can go.
Yes, sir, definitely.
Yes.
There is no bar.
There is no
They
bar, sir. He
can.
can.
Sir, actually, what they do is they go one by one, sir, to make your life irritable. First, they
Miserable.
go to
Miserable.
the police station, then after you file a reply, they go to the medical council. Likewise, they can really make your life hell.
Sir, in the Consumer Council, can we say that already he has filed a complaint with the Joint Director of Medical Education where the process is on? So till he gives the verdict, it should be kept in abeyance.
No,
We
sir.
cannot argue with that.
Simultaneously, they are taking up all the cases.
Oh.
There
I think,
are three different systems, and at any given point of time, at all three at a time, he can file a case, sir.
sir, already a question has come just because we are leading the debate. Is there any law or mandate mentioning accountability of negligence of PG resident in case of procedure related complication?
So
If
shall
the
I
P-
take this? Shall I
Yes,
take
yes,
this
yes,
case?
Please,
Please,
yeah.
please.
Sir, this is now the latest case which has come giving a 1 crore compensation that Kamini Hospital. Sir, I think everybody must have read that. That a patient was given, I think, 10 p.m. and a senior resident has given anesthesia. Gynecologist is the I think assistant head of the or professor of the senior resident, and this is in that Kamini hospital. And what has happened is that the patient was given spinal anesthesia at around 10 p.m. Baby is delivered, and then what happened was that after some time they had to give supplement with GA. So the headlines are saying because anesthesia was given twice, okay, it has caused multiple problems, and but if you read the what exactly happened, in that case, the patient was taken to the ward, and the patient was, there was nobody, no, as soon as the case is over, this is our main problem, sir, that as soon as the case is over, the patient gets shifted to the ward because it is just an LSCS case. There was nobody over there. For 2 hours, the patient was semi-conscious. And what
Yeah.
the nurse told the relatives, so the relative says, why isn't she waking up? So it was because of hypoxia. And
Yeah.
they said it's, you know what happened, that because at the time of closure, they had to give more anesthesia. So a nurse telling the patient that the patient is not waking up because anesthesia had to be given twice. And now
Right.
that sentence has been picked up by the media
Media.
and everything. And the senior resident is also implicated in this case. So it is the head of the department. It is this professor who actually did the case, senior resident who left immediately after the case is over. So this is a case of post-operative hypoxia. The patient actually had some bleeding also. She's probably gone into shock, which nobody has realized. And she dies in an hour's time. She was not even shifted to ICU. This is a proper hospital, means medical college. So definitely they have some ICU facilities, but they were not. Then somewhere early morning or 8 o'clock, the nurse calls the resident and everybody, and then they shift to the ICU. By the time, I think within 1 hour or 10 a.m., she has died.
Madam,
Madam,
I
can
request you to answer the question straight. He is
Yeah.
asking
Yeah.
if a
Yes.
PG, if a PG has done the case, who is responsible, whether the PG or the assistant in charge or the HOD in charge?
Master,
So
Sir,
master.
delegate.
in this case, the PG
No.
resident has been named.
Sir,
Sir,
moderator, sir.
delegation of a duty or crucial duty in anesthesia to a trainee junior doctor amounts to breach of duty, and the liability is on the senior if he is not
Correct.
supervising him. This is very, very important because the PG is also responsible provided he exceeds his limitations. For example, he has given a spinal anesthesia under the supervision of the senior, and he wanted to extend the surgery without his knowledge. He tried to intubate the patient, and it was endoesophageal, patient into the hypoxia. So in this case, PG has exceeded his limitations without bringing to the notice of the senior. He is also partly responsible because he is already registered under the medical council. The second part is the senior, he allowed him without his knowledge or with his knowledge, without his supervision. So he is also liable. There are 1 or 2 cases in this, because one case probably Pratibha will also agree with me. A faulty intubation was done by the junior anesthetist or PG anesthetist, and because he consultant are very confident because he's an exam going student and probably he would do it. He went for a cup of tea or some breakfast, so he failed to intubate and the patient went to the hypoxia and went into coma. So in this case, both of them will be responsible, sir.
Sir Krishnamurthy, sir.
I want to ask one thing. Madam, Kane, madam, can you give me the title of that case, madam? Kamini Hospital. I will look up for the judgment.
Yeah, I have,
The
sir.
judgment is with us, sir.
Okay.
We've got the judgment also. In fact, we were trying to, the MLSI was trying to
Yes.
tell the doctor, I mean, we had actually approached that hospital to, try to appeal.
Help them,
But they
yeah.
have to put down 50 lakhs to appeal.
Yeah.
Madam,
So
that is
that
common
is
in
our
Hyderabad.
problem, sir, now.
Madam, it is common in Hyderabad.
Sir, I'll tell you.
Which hospital?
I too
Sir,
have
this
it.
is just 2, 3. 1 second. I will tell you exactly what this is.
Because it is eye opener.
Yeah, it's
No,
eye
no.
opener, definitely, sir.
Sir,
No,
before
this
that.
is 5 days ago. It was headline.
Yes. Madam, you please search. I will ask both
Yes,
these legal sirs another question for the benefit of
Yeah, please.
these
Yes, sir.
delegates. Sir, you say sometimes postmortem is needed, postmortem is not needed, that and all we are saying. But in my personal opinion, postmortem is not decided by us. It is decided
Yes.
by the police. So the moment you lodge a police complaint, the matter is over. And whether we agree for the postmortem or the attendants refuse postmortem, that is not a concern. So if at all we want the postmortem is to be on, whether we lodge a complaint to the police, and the police, in case if they decide the postmortem is not needed because they will be pressurizing the relatives will also pursue the police not to pursue the case up to the postmortem. In that case, if postmortem is not done, and if the relatives approach the consumer court at a later date, then what is the inference, sir?
Sir, in this case, when you know that, when you do not know the cause of death, okay, you have to inform the police.
Yes.
One thing, you know the cause of death, the relative don't accept the cause of death. That time you have to inform the police. There are two basic things. So you don't ask for the postmortem. Just to make the police, ask the police to make it the MLC. Then they know the procedure, what to be done, what is not to be done. If they console the patient or discuss the patient, okay, doctor has done their best. We have gone to the Panchanama, we have seen the records, and there are no chance for you to win the case or something like that. Probably they take undertaking from them and they release the body with a B report, whatever it is. So our duty is only to inform the police, not to ask for the postmortem. It is the do or not, depends upon the investigating officers.
Sir, may I? I've found the case.
Yes, madam.
Yeah, please.
Okay, so this is before the District Consumer Disputes Redressal Commission at Nalgonda.
Oh,
Nalgonda.
Yes.
Andhra.
Okay, so this is consumer complaint number 11 of 2021. Date of disposal is 30/10/2025. So that is just, about a month ago. And so
Community hospital Nalgonda.
Pardon?
Date of disposal.
Community hospital.
Sir, I'll tell you where they have. So this is the petitioner. Now they have filed against Dr. Madhavi, professor and head of the department obstetrics, Kamini Institute of Medical Sciences, Shri, Kamineni.
I know. Kamineni, I have visited. I have delivered a lecture also.
Kamineni.
Yeah, Kamineni
This
is a popular.
Sripuram, Narkatpalli.
Narkatpalli.
Okay. So there is Dr. Madhavi, head of the department OBS, Dr. Sunita Mishra, professor OBS and Gynec, Dr. Prasad, anesthesia senior resident.
It is Telangana, madam. I think it is Telangana.
Telangana, sir.
Narkatpalli is in Telangana.
Okay, so Telangana, yes sir, Telangana state. Then assistant professor of emergency medicine, because she did go to ICU, and the hospital. So these are the things. So Dr. Prasad, anesthesia senior resident and consulting doctor.
In this case, I want to say one of my personal experience. In the GH, we anesthetized the case. Actually, I don't know who has anesthetized that, because the postgraduate will be anesthetizing. As an assistant, I am in charge for that case. The patient developed left hemiplegia on the 7th postoperative day and referred to Medical College Hospital from the obstetric hospital. Both are government only.
Yeah.
And there the patient died. So they have filed the case in the consumer court, and as a government, I said only government lawyer has to make the defense, because the government will pay the compensation. But unfortunately, that lawyer not appeared for the case, and ex parte it was decided 1,35,000 compensation was awarded, including me also. So the patient died on the 14th postoperative day, but I was also included, and OG, PG, and this surgeon. So all the three were made. Then we appealed in the High Court. So our lawyers appeared, personal lawyers, but the High Court said, because I have given in my reply counter affidavit, in the entire history of anesthesiology, if any patient develops hemiplegia after spinal anesthesia, then I can be sued. Because as a anesthetist, I have no access or reason to visit the postoperative ward I have mentioned. Then the court also mentioned this cerebral venous thrombosis is acceptable complication, which has been documented by the CT scan. So the doctors are not negligent. Even if the compensation is required, the government is paying the sterilization cases, because the patient is a repeat cesarean. So they can pay it from the corpus fund. So that is the thing. So even if the government advocates appear, we have to see to that they appear, or we have to make them to appear. Another case of another question has come up, sir. Unavailability of proper gadgets for procedure or malfunctioning amidst the procedure. How do we be accountable? Like ECG or pulse oximeter suddenly not functioning.
So that only you can answer, sir.
Yeah, see, actually, in this, I want to add now the debate is AI is giving solutions mainly in radiology. AI is offering the diagnosis. So, in case in anesthesiology, also, if AI is implicated, then who is responsible? It is
The
very
doctor is
clear.
always
Doctors are always responsible. So,
Doctors always.
the company, as Dr. Muthukumar Rajagopalan has asked his question, even if there is a malfunctioning of equipment, always company will not at all be responsible. Even we can sue the company in consumer law that your this thing has not worked. But if you go to the court and mention that the machine has not worked, the court's immediate reaction will be, why you have not checked whether the machine is working or not. So the blame will be always on the anesthesiologist. So we have to acquire, and if this man calls me personally, I will know what to do. I will inform him what to do. But in the podium and the YouTube recording, we cannot say like that. So,
So standardization of and minimal monitoring
yes,
standards have to be maintained, actually.
doctors are responsible. Even now, even if AI comes, natural intelligence is responsible. Compulsory.
Yes, yes.
They call it human oversight.
Yes, yes.
Always.
Yes, yes, yes.
Sir, if your machine stops functioning midway during the surgery, then you make an attempt to get it from nearby clinics and have those call records ready. You can prove that you made every effort.
Yes. So effort has to be made
Yes,
too.
every effort you have to make to get the instrument from a nearby clinic or hospital, and you must have this call logs also ready.
This is just like asking, sir. This is one
Very difficult, I know.
Sir, a very good orthopedic surgeon. They were operating. It is long back, 1990, when they were operating. The staff nurse swooned and fainted on the ground. So the anesthetist went to check up the pulse and resuscitate her. So he resuscitated the staff nurse, but the patient on table died. So that is the problem now. So these sort of things, it is very difficult. Same way in a government hospital, post laparotomy, I mean, peripheral sterilization cases are going on. One case has gone to the post-operative ward, shifted to post-operative ward. The nurse calls the anesthetist, patient is vomiting. So immediately they rush to the post-operative ward, patient vomiting, aspirated, death. They are coming back to the theater, on table, patient, death. So two deaths simultaneously is very difficult to defend. So the government has transferred and imposed many punishments like increment cut and all. So these are all the things beyond our capacity. Even in one case, patient has developed hypoxia during anesthesia. So the anesthetist has administered 100% oxygen. But again, the patient desaturated. So they intubated and ventilated. Desaturation, calling the anesthetist from the neighboring theater, patient dead. Reason that anesthesia cylinder was filled up with nitrous oxide.
Yes,
He say it is pin index, everything, but see, but again, the anesthetist was sacked. He was imposed punishment. See what he can do. Anesthesia cylinder is applying.
He himself cannot take it. And
it has happened in TamilNadu. So what I want to say,
happened in Kanyakumari.
At that time, I don't want to mention the place, Tamil Nadu, but see, the thing is, we at that time, one anesthetist from Maharashtra, Nasik, when I was discussing this case, then he said, sir, if you have a FiO2 analyzer, at that time only I know the implications. If we have FiO2 analyzer in the boils apparatus, then it will be good. But when we are going as an expert, we are not supposed to say this sort of an intricacy. Just because FiO2 analyzer is not used, the patient is dead. See, it is a criminal offense. The manufacturer has filled up oxygen cylinder with nitrous oxide. How he has overcome the pin index, how it was done, he should be taken to task. It is a criminal negligence. But
even in Consumer Code 2019, the manufacturer, he becomes a primary liability.
At least the government has to sue the people who as manufacturer, they have to be sued. It is very difficult. So I think good discussion, sir. Till 8 o'clock we have come. I thank the legal luminaries and the emerging legal luminary, Dr. Rutuja. See the way in which she is talking like a liar. I think she has the potential. She can follow Dr. Pratipa Kane. And Madam has enumerated the documentation, encoding the documentation really superb. The case histories which they are showing, actually, that will stand in the mind of the people. We should know that it is because of judges only judgment comes. They are not medical luminaries, just like if and but they will put. So I thank Madam for the expert commentary regarding
Thank you,
that.
sir. Thank you very
So
much.
we thank Dr. Krishnamurthy, sir.
Thank you, sir. Thank
Our
you.
beloved lawyer from TamilNadu, actually, anesthesia qualified, and he has given the negligence part. The best part is he has declared what is not negligence. So, more than negligence, he has declared what is not negligent. And our lawyer from Dharwad, the moderator, Dr. Shivkumar F Kumbar, sir, he's a good friend of us and he is interested very much and he's working for the cause of anesthetist. And I thank all the three and the budding legal luminaries who is going to join our medical legal club, Dr. Rutuja.
Rutuja, yes.
Thank you so much, sir.
Simply,
Thank you,
and
ma'am.
I request all the three faculties, legal luminaries, please join with me. I will get back to them.
Yes.
They will be in the group ISA legal action group. I'm tomorrow I will formulate the project report, how to go about it. That
Yes.
is three from GC, three anesthesia qualified, the three are on the stage, and three advocates. Already I have picked up one advocate from Maharashtra. I have requested another GC member from Maharashtra to pick up a lawyer from some other state because already I have picked up a lawyer from Maharashtra. Two more lawyers will be there. So please help us. We will work out the methodology, how it could be done.
Yes.
And now it is time for the ClearNet to pass the concluding remarks and close the session.
So, thank you so much, everyone, for joining this session. Clarinet is really glad to have all these brilliant people together. So, with all your permission, I'm closing the session for today and looking forward to hosting you again. Thank you so much, everyone, for joining.
Thank you.
Thank you.
Thank you.
Thank you, sir. Thank you, everyone.